Entering the United States legally is an extremely difficult process. Each year, millions apply for visas to enter into the United States, and only thousands are granted them. So the question is, why is it so difficult to enter the country legally, and what steps have to be taken to do so? Before we can answer that question, let us start with a brief explanation of the history of the American immigration system. Migration to the United States can be dated back to the 1600s when a group of settlers known as Pilgrims fled from Europe in search of freedom to practice their religious faith. These pilgrims settled into what is now known as Plymouth, Massachusetts, and the group was comprised of nearly 100 people. It's actually from these pilgrims where our Thanksgiving tradition derived, and it was a harvest between them and the Native Americans that actually started the idea of the tradition of Thanksgiving. Around the same time that the Pilgrims settled into the United States, a group of Africans were unwillingly stripped away from their families and transported to Jamestown, Virginia as slaves. Throughout the American colonies, these slaves were primarily in the South and were used as laborers and worked in cotton fields. Slavery lasted for nearly 200 years, and it wasn't until the American Civil War, which took place from 1861 to 1865, that these slaves gained their freedom after the Emancipation Proclamation was issued by Abraham Lincoln, which declared that all slaves shall be free. During the Civil War, millions of Irish natives also migrated to the United States due to a nationwide famine. It wasn't until this time that immigrants were primarily women. Also, during the mid 1800s, a swarm of Mexicans migrated to the United States. Many of these people settled into states such as California, Nevada, Utah, Arizona, New Mexico, Colorado, Texas, and several other states. However, after the Treaty of Guadalupe Hidalgo, which ended the Mexican American War, the number of Mexicans who migrated to the United States dropped significantly. Also during that time, President Benjamin Harrison used Ellis Island as a federal immigration system. As many arrivals from Northern and Western Europe took place, the United States tightened their immigration policies. The Immigration Quota Act of 1921 and National Origins Act of 1924 strictly limited the number and nationality of immigrants allowed into the United States. Great Depression in the 1920s and World War II, America's foreign-born population decreased significantly. This pushed Congress to pass the Immigration and Nationality Act of 1965, which allowed Americans to sponsor relatives from their countries of origin. Also known as the Hart-Celler Immigration Bill, the Immigration and Nationality Act completely wiped out the immigration quota of 1921. The new act is what established the basic structure of our immigration system today. So now back to the main point. Why has it been so difficult to enter the country legally, and what steps have to be taken to do so? The answer is simple: time and money. The immigration process is a tedious, lengthy, and costly process. The first step in the process to legal immigration is to apply for your non-immigrant visa. Once you have submitted your application, you must wait for an interview at an embassy or consulate. Your immigration officer will then advise you if your petition has been approved or denied. However, just the initial steps for this process is very costly and very time consuming, and even to qualify for a non-immigrant visa is painstaking. Just to name a few, there are business visas, tourist visas, student visas, religious workers visas, temporary workers visas, and much more. These visas can range in duration from several days up to 6 years. The majority of non-immigrant visas cost $160 per person to apply. It may not sound like much to you and me, but think about it. A person in a country such as Haiti, for example, lives on less than $1 per day. In addition, consular processing fees are $492 per person for family-based petitions, and the fees vary for other petitions. Not to mention, many immigrants have to hire a professional to complete the paperwork for them. To make matters worse, the immigrant will have travel expenses. A plane ticket can cost hundreds of dollars. Now keep in mind that these non-immigrant visas are temporary. Most of these visas do not grant non-immigrants the right to work, the right to certain types of aid such as car insurance, health insurance, life insurance, the right to drive, the right to go to school, or any types of status in the U.S. unless if their visa specifies it. Now, once in the United States, the non-immigrant may apply for an extension of visa if he or she feels as though they may overstay their visa. Overstaying your visa may make it difficult for re-entry into the United States. This process can be done through the United States Citizenship and Immigration Services, also known as USCIS. Earlier, I mentioned that the Immigration and Nationality Act of 1965 allowed Americans to sponsor their relatives from their countries of origin. Now, what is a relative? In terms of immigration, a relative can be spouses of a U.S. citizen, unmarried children of U.S. citizens, which includes adopted children and stepchildren under some circumstances. Also, a relative can be a parent of a U.S. citizen. These relatives are all categorized under preference categories. The ones I just mentioned are under preference category 1. In addition, the American immigration system allows brothers or sisters to petition for each other. The American immigration system has 4 preference categories. The first one I just mentioned. The second one, which is subcategory A, allows legal permanent residents to sponsor their spouses and minor children. The second preference category B allows legal permanent residents to sponsor their unmarried adult children. The third preference category allows U.S. citizens to sponsor their married adult children. And the fourth category allows U.S. citizens ages 21 or older to petition for their brothers or sisters. The relatives I just mentioned are the only ones who can petition for their family members for a green card, or what is also known as an immigrant visa petition. The purpose of the preference categories is to establish priority on when the visa will become available to the respondent or family member. The higher you are on a preference category, the quicker you will receive your green card. However, the process of obtaining your green card is not that simple, and it's more than just an application. First, you must have what is called a visa number before you can adjust your status to a permanent resident. The relatives I just mentioned in the preference category 1 are the only ones who obtain a visa number almost immediately and can actually submit their adjustment of status with their immigrant visa petition. Next, the family member must submit proof of legal entry into the United States. If the respondent entered illegally, then they must go through a different process to obtain their green card. There must also be evidentiary support to show the relationship between the petitioner and the respondent. This can include marriage certificates, birth certificates, affidavits, and so on. A medical exam and passport photos must also be submitted with the application. The beneficiary must also submit an application for employment authorization and an application for a travel document if he or she chooses to travel outside of the country. In addition, the beneficiary must submit the appropriate filing fees with their application. The current fees on the USCIS website is $420 for the actual immigration visa petition, $985 for the adjustment of status, and $85 for a biometric service fee. Once the complete application is received by USCIS, the beneficiary will be called to a biometric service fee appointment at their local USCIS office. They will receive notice that the petition has been approved and will be called to an interview for their adjustment of status. Once the adjustment of status has been approved, they will have a temporary condition on it for 2 years. The final step is to submit your application for citizenship after 3 years if you are married to a U.S. citizen or after 5 years of being a permanent resident. Once you have been naturalized, you are officially done with the immigration process. I know that I just provided you with a lot of information that may be a lot to retain and difficult to understand. So, I have created a brief script to better explain the American immigration system. Let's say, for example, that Juan is a 24-year-old male from Mexico. Juan has been working as a cook for the past 3 years in a well-known tourist restaurant. Juan's dream is to become the executive chef of a 5-star restaurant in the United States. However, Juan only has one aunt and one cousin who lives in the United States. Since these relatives are not considered immediate, they are unable to petition for Juan. Juan's cousin Alejandra lives in Orlando, Florida, and works at Disney World. Alejandra hears about a job opening at Disney's Epcot Authentic Mexican Restaurant, where she also works. She puts in a word for Juan, and Disney decides to file a non-immigrant petition on Juan's behalf with USCIS. Juan is now 25 years old and has gone to his interview and has been approved for a non-immigrant temporary worker visa for 6 months at Disney. After receiving his visa, Juan purchases his plane ticket and comes to the United States, leaving his mother and his siblings behind. While working at Disney for several months, Juan meets a woman named Lily, who he sees every day on his way to and from work. One day, Juan decides to approach Lily and creates a conversation with her. Every day for the next month, Juan and Lily walk to and from work together. The two quickly fall in love and get married 5 months later. Lily happens to be a U.S. citizen and petitions for a green card for Juan shortly after they get married. Since Juan did not enter the country illegally, he has no issue with the process. He simply overstayed his visa and was without status and was unable to work or perform basic daily living functions in the United States. Since Lily, as Juan's spouse, is a U.S. citizen, Wall falls under Preference Category 1 and a visa number becomes immediately available to him. 4 months later, Juan is called to a biometric service appointment, and 2 months later, his initial interview. By this time, Lily and Juan are expecting their first child. Juan goes to his interview and is approved for a conditional permanent resident. After 2 years, Juan files another form with USCIS to remove the conditions on his permanent resident card. A year later, Juan applies for naturalization and provides all the evidentiary support and becomes naturalized with the United States of America. Juan then petitions for his mom and his siblings who are back in Mexico, and the process starts all over again.